There can be a variety of different reasons to involve the court in your family law proceedings. In Alberta, family law proceedings can take place in the Provincial Court of Alberta, the Court of Queen's Bench, and even in the Court of Appeal. In either court, a case usually begins with the filing of a claim that sets out what the issues are, what is being sought, and the underlying basis for the relief being sought. Provincial court is most often accessed by common law couples, but can be used by married parties as well for the resolution of some issues. The Court of Queen's Bench can be accessed by either married or unmarried parties, but is required for the granting of certain relief, including a divorce. Our lawyers can help you determine which court is best suited for your needs and goals. Regardless of which court is appropriate for your matter, a comprehensive resolution to all issues in litigation dispute occurs at a trial, and there are several steps that occur prior to a matter progressing to the trial, including questioning, undertaking, responses, and the resolution of matters that require more immediate decisions. Disputes that require faster resolution are generally decided on a temporary basis. An application is brought to decide what should occur between the time of the application and the trial. These types of decisions often include parenting, child support, spousal support, and who can reside in the home. These temporary decisions are generally referred to as interim decisions or interim applications. In an application in the Court of Queen's Bench, the process typically starts with an attendance at the Family Docket Court. The Family Docket Court is an administrative court where parties and counsel attend to obtain a further and more substantive court date. More often than not, these matters are directed to alternative dispute resolution, which through the court system includes an appointment with resolution counsel, which is an appointment with a court lawyer where the parties try to discuss resolution of their outstanding matters, a DRO, which is a 1 hour to 1.5 hour appointment with senior family counsel within the city of Calgary and is intended to address and discuss matters relating to support, an EICC, which is an approximately 1 hour appointment with a family law justice where the parties will discuss their outstanding issues, though to qualify for an EICC, there must be at least one child of the marriage. The justice at the EICC does not have decision-making authority in these sessions, but can pronounce orders that are arrived at by consent. If your matter is urgent, or if alternative dispute resolution has been attempted unsuccessfully, it is possible that the court sends the matter to a contested hearing, which could be a morning chambers application, which is a 20-minute court appearance where small interim issues can be argued over and an interim decision can be made on things such as child and/or spousal support, travel authorization, listing a home for sale, direction for sale, or other small issues. A domestic special is a more lengthy and dedicated hearing of your matter, usually about 2 hours long. There are a variety of materials to file in advance, and at the hearing, which is usually several months from the date of booking, the justice can make a decision if they believe it is appropriate. The domestic special process is not a final order, however, and if the parties are seeking a final order and/or any property order, they will be directed to trial process. A Provincial Court of Alberta appearance is often the result of an unmarried couple filing a court application for parenting and/or support. Once that application is filed with the court, the parties will be given a court date and the materials must be served on the non-filing party. At the court appearance, which is called Provincial Court Docket, the court will ask questions about your matter and determine the best next steps for your family. Oftentimes in provincial court, the matter is sent to judicial dispute resolution, which is a court appointment a few weeks or months later, where the parties meet with a judge to discuss their case and the judge will try to mediate a resolution of outstanding matters. Other times, the matter will be sent through a pretrial process in order to book a hearing date for a judge to make a decision in your matter.